Hey, Commissioners, it looks like the attendee list is populated. You're free to start the meeting.
Thank you. The regular meeting of the Civil Service Commission for February 4th, 2026 will now come to order. Welcome in-person and online attendees. If you want to provide oral arguments on any of the agenda items, please be sure you follow the instructions on the first page of the agenda. If you're attending this meeting in person and you would like to pull an agenda item for discussion, when asked, please stand and identify yourself by name or number, and we will return to your item after the consent agenda is approved. Attendees joining this meeting using the Zoom application will alert Commission staff of your intention to speak about an agenda item by using the Q&A function at the bottom of the screen. Please include your name, telephone number, or other identifying feature you selected when logging in, and the agenda item number you want to speak about. Attendees who dialed into today's meeting, please press *9 on your telephone to raise your hand to alert Commission staff of your intention to speak about an agenda item. When called upon to speak, please unmute yourself using *6 on your telephone. Roll call. Will the Commission Secretary please take the roll?
Commissioner Bassett, Commissioner Coleman,
Present.
Commissioner McGovern,
Present.
Commissioner Montenegro,
Present.
Commissioner Rodriguez Kennedy.
May I have a motion to approve the minutes of the regular meeting of January 7th, 2026?
Madam Chair, if it pleases fellow commissioner, I would so move.
Second.
Thank you. Is there any discussion? Will the Commission Secretary please record Commissioner votes?
Commissioner Coleman,
Aye.
Commissioner McGovern,
Aye.
Commissioner Montenegro,
Aye.
The vote was unanimous. Members of the public may address any matter related to the Civil Service Commission other than items that are on the agenda for today. The total amount of time allotted for public comment will be limited to not more than 2 minutes unless the Commission President agrees to extend the time. Do any of the attendees want to make a public comment about any matter related to the Civil Service Commission, but not on today's agenda? If so, and you join the meeting using Zoom, please use the Q&A function on the bottom portion of the screen to inform Commission staff. If you dialed into today's meeting, you may press *9 on your telephone to raise your hand to alert Commission staff. When called upon to speak, please unmute yourself by using *6 on your telephone. We will need to wait a minute in the event somebody wants to make a comment and is attempting to alert staff now. Will the executive officer please start a timer?
Yes. Commissioners, 1 minute has passed. We've received no request to make a public comment.
Thank you. We will now move on to agenda item discussion. Do any of the attendees want to pull an agenda item for discussion? If you're attending this meeting in person and you would like to pull an agenda item for discussion, please stand and identify yourself by name and number, and we will return to your item after the consent agenda is approved. If you're speaking for an appellant or complainant, please use their assigned number. If you join the meeting using Zoom, please use the Q&A function on the bottom portion of the screen to inform Commission staff of the agenda item you want to speak about. If you dialed into today's meeting, you may press *9 on your telephone to raise your hand to alert Commission staff. When called upon to speak, please unmute yourself using *6 on your telephone. We will need to wait a minute in the event somebody wants to pull an agenda item and is attempting to alert staff now. Will the executive officer please start a timer?
Yes. Mr. Cunningham, I see that you've raised your hand. Which item do you want to pull for discussion? And this is in open session. I'm sorry, Mr. Cunningham? Mr.
Okay.
Cunningham?
I'm getting there. Thank you. Can you hear me now?
Yes, we can hear you.
Okay, I'm pressing every button.
Okay.
I
Just tell us, it's item number 2 that you want to pull for discussion, I assume?
That is correct.
Okay. We will come back to you to get your input when we get to that item. Please remember that we are in an open session.
Agreed. Thank you.
Okay, thank you.
Any others?
Commissioners, one person has requested to pull item number 2 for discussion. We have received no other requests to pull an item for discussion.
Thank you. We will now move on to formation of consent agenda. Will the commission secretary announce the items forming the consent agenda?
Commissioners, item number 2 has been pulled for discussion. Therefore, item number 1 forms our consent agenda for today.
May I have a motion to approve the consent agenda?
So moved.
Second.
Thank you. Is there any discussion? Will the commission secretary please record commissioner votes?
Commissioner Coleman,
Aye.
Commissioner McGovern,
Aye.
Commissioner Montenegro,
Aye.
The vote passes unanimously. We will now move on to our discussion items. Agenda item 2, which is Commissioner Montenegro's report on a discipline hearing. Do any of the attendees want to speak about this agenda item? We've already been alerted one does. If so, and you join the meeting using Zoom, please use the Q&A function on the bottom portion of the screen to alert commission staff. If you dialed into today's meeting, you may press *9 to raise your hand to alert commission staff. We will need to wait a minute in the event somebody wants to speak about this agenda item and is attempting to alert staff now. The executive officer, please start a timer.
Yes. Commissioners, we've received no additional requests to speak to this item, so we do have Mr. Cunningham that would like to speak. Mr. Cunningham, you'll have 2 minutes to speak, so please unmute yourself and you can begin.
Okay, can you hear me okay?
Yes.
That 1 minute, that 2-minute timer on the top left-hand corner is very daunting for an Irish lawyer, but I'll do the best I can. Commissioners, thank you so much for taking the extra time. I know you continued this matter. I made the assumption you continued the matter to give it the due review that is necessary. I think there is no dispute, both on the department and the county side, that this employee was a extremely proficient, well-regarded employee by all accounts. There was no evidence, no allegations that she was not able to perform the functions of her job at a very high level. We get involved in this particular matter because of a term called expungement, and it was discussed and reviewed at the hearing in this matter. And it is incredibly complicated to understand whether or not someone who has a charge expunged is actually still someone that you're not supposed to have a particular relationship with without telling your employer. This case is born out of that confusion. Evidence was presented by the Peace Officers Standard Training Bureau, POST, that they do not say that cases involving relationships, especially ones that is complicated and wrought in emotion, are automatically a termination. It is submitted that the mitigating factors in this matter are significant, that this employee is a valuable employee to this department by all accounts. And this mistake in terms of the law, expungement, and judgment as well, cannot form the basis of ruining this particular employee's job with the county, but indeed any further career with law enforcement. She's a valuable asset, and I'd hope and ask that the commissioners consider that before this final decision is rendered. Thank you, Mr. Adams. Thank you, Adams. Thank you, commissioners.
All right, Commissioner Montenegro, you may now proceed with your report.
Thank you, Madam Chair. Appellant 2024-064, the employee, appealed an order of termination and charges removing her from the class and position of Deputy Sheriff Detention/Court Services, class number 5757, in the Sheriff's Office Department, which was presented to the Civil Service Commission. The Commission appointed me, Commissioner Joe O. Montenegro, to hear the appeal and submit findings, conclusions, and recommendations to the Civil Service Commission. Thereafter, the matter was duly noticed and a hearing was held on November 13th and 14th, 2025. The cause of discipline were failures of good behavior, dishonesty, and acts incompatible with and or inimical to the public service. The finding of the facts. In January of 2018, SS was arrested and charged with violating California Health and Safety Code Section 11379A, a felony. Following her arrest, SS agreed to enter into a plea agreement with the District Attorney's Office, resulting in a felony conviction of a charge of transportation of methamphetamines in violation of Health and Safety Code Section 11379A. She was incarcerated in county jail for a period of 5 or 6 months, released in and around the summer of 2018, and placed on probation. After successfully completing probation, SS petitioned the courts for an order of relief under California Penal Code Section 1203.4, i.e., also known as a dismissal, permitting her to withdraw her plea of guilty and enter a plea of not guilty, and further allowing the courts to dismiss the accusation or information against her and release from her all penalties and disabilities resulting from her conviction. The petition for dismissal was approved on October 1st, 2021. 2, the employee and SS began a long-distance relationship by meeting online through social media and remained an exclusively online relationship until January of 2019. When they met in person and began a long-distance relationship with the employee living in Los Angeles County and SS living in San Diego County. After she graduated from California State University at Long Beach in May of 2021 with a major in criminal justice, the employee worked for 6 months as a security guard in Los Angeles County until she moved to San Diego County and began living with SS in late January or early February of 2022. Before moving in with SS during the period of their long-distance relationship, SS had never disclosed her criminal history to the employee. However, 2 or 3 months before the employee moved to San Diego County, and after obtaining the dismissal order, SS disclosed a portion of her criminal history to the employee. This occurred in or around November of 2021. The disclosure SS provided to the employee included information that she was arrested, that she spent time in county jail, that she was released in the summer of 2021 on probation, that she completed her probation successfully, and that it had been expunged. In November of 2021, the employee applied for employment as a deputy sheriff for the department. On February 19th, 2022, the employee completed and signed the questionnaire. Her answers to question 315 in the questionnaire: are you currently living with a convicted felon or with someone who is on parole? Was no. Her answer to question 328 in the questionnaire: has anyone in your home ever been arrested? Was also no. Both answers were untrue. The employee and SS were never married. The employee and SS never registered as a domestic partner with the California Secretary of State. In conclusion, cause 1, the evidence does not support a violation of Civil Service Rules 7.2R regarding failure of good behavior, in that when the employee filled out the questionnaire, she was in a relationship with SS, including living together. At that time, the employee was aware that SS was arrested, that she was convicted of a felony, and she spent 5 to 6 months in county jail. The employee argues that her relationship with SS qualifies for the unavoidable exception to the department's policy, Section 2.9 of the Sheriff Rules of Conduct, prohibiting an employee's association with persons whom they know or should know or have reason to believe are convicted felons. The exception is where unavoidable because of other personal relationships. Unfortunately, there is no definition of personal relationships in Section 2.9 that would qualify for establishing unavoidability. However, both the notice of intent of termination and charges and the order of termination and charges do include examples in the negative. For example, not married at the time of employment, not related by birth, do not have children in a relationship, and then adds a fourth condition, and there is no evidence of significant financial ties, cohabitation, shared bank accounts, etc. The employee points to the parenthetical clause, cohabitation, shared bank accounts, etc., and argues that she and SS did in fact live together at the time that the employee completed her confidential orientation questionnaire, further supporting her position that the relationship was not avoidable. The employee presented evidence that SS opened an account at Navy Federal Credit Union, NFCU, on December 21st, 2022, which was established as a joint account and included the employee as a member, and SS was the primary owner. The NFCU account was not consistently shared as a joint account, as the employee was removed from the account almost 7 months later on July 12th, 2023, and then re-added on March 20th, 2024, and then removed again on October 14th, 2025. Addressing employees' contention, the department presented testimony of the lieutenant who conducted the disciplinary recommendation and rationale, R&R. Following the internal affairs investigation by the sergeant, while the sergeant's investigation report finds that the employee's lack of knowledge supporting a finding of not sustained as it relates to cause 1, did not knowingly associate with a convicted felon. On the brief that the dismissal of the felon charges brought against SS, post-conviction and probation eliminates the conviction as if none of it ever existed. The lieutenant found that the internal affairs investigation failed to consider ongoing violations post-investigations once the employee was aware of the policy and the actual status of SS, actual status of SS as a convicted felon. The dismissal notwithstanding, the lieutenant then restored the cause 1 charge with the language added as generally reflected above. When questioned about his interpretation of unavoidable, the lieutenant used the example of a brother who is a convicted felon, a relationship that would exist from birth. I can't just walk away from that relationship. He then explained further, on the other hand, An unavoidable relationship would be, for example, a dating relationship, where you have the option of dating that person or not dating that person. The commander, who later reviewed and approved the notice of proposed disciplinary action in this matter, was asked his understanding of unavoidable and replied in part, "We can't pick our family, and we certainly have individuals, deputies, and many other individuals that have brother, parents, maybe siblings, children that are involved in criminal activity. I believe that creates an unavoidable relationship because of obviously close familial relationships. With respect to married couples, his response would depend on when couples were married when determining if the association was unavoidable." The commander's R&R included this analysis. By the conclusion of the investigative interview, the employee had been made aware of the policy regarding association and reasonably should have known that her continued relationship with SS would be in violation of the policy. During my meeting with the employee on May 17th, 2024, On May 17th, 2024, she told me that she was still engaged to SS, which is a continued violation of the SDSO policy. It is a problem, however, that even those involved in finding the relationship between the employee and SS was avoidable, and thus establishing a violation of Section 2.9, are not consistent by including the example of cohabitation, shared bank accounts, etc., to define an unavoidable relationship without further explanation or change by command. This hearing officer isn't convinced that the department met its burden of proving a violation of Section 2.9, and cause 1 is unsustained. Cause 2, the evidence supports a violation of Civil Service Rule 7.2D regarding dishonesty. It is during her background investigation that the employee failed to acknowledge that SS, her girlfriend and roommate, had been arrested and charged with a felony, that SS entered into a plea bargain in which she admitted her guilt of committing a felony and was sentenced to custody in the county jail with credit for time already served, resulting in her release and probation. Prior to her employment, the employee was required to fill out a lengthy questionnaire, including questions related to her relationship with any persons who have been arrested and any relationships with a convicted felon. The questionnaire advisement makes it clear that answers given by the employee are expected to be complete and honest, and that if at any time it is determined that any of the responses were not honest, the employee could be removed. When specific to her relationship with SS, question 115 clearly asks if the employee had knowledge that SS was a convicted felon. Again, specific to her living arrangement at the time, question 328 seeks information whether SS had ever been arrested. The employee, knowing that SS had, 1, been arrested, and 2, convicted of a felony by virtue of her incarceration for a period of time or 6 months, 5 or 6 months, was likely a convicted felon. Although it is plausible that the employee accepted at face value the explanation given by SS, that is, that her conviction was expunged, the results being that it is as if it never existed. This explanation was not accurate. SS should have known that the dismissal does not remove the fact that she was and will always be a convicted felon. And the employee should not have accepted the explanation of SS, that the dismissal made it as if the arrest and conviction never existed. It remained the employee's responsibility to answer question 315 and 328 honestly and accurately. In the least, the employee should have made a better effort to understand what the dismissal means. Having a bachelor's degree with a major in criminal justice, the employee should have a better understanding of the workings of the California criminal justice system that the average person, in particular, what an arrest means, what a conviction means, and what a felony is. It should have become apparent that a Penal Code Section 1203.4 petition, if granted, does not eliminate an arrest, nor will it eliminate the record of a conviction for certain purposes. What it does is change the results of the criminal matter to a dismissal. Why it is often referred to as an expungement, the record of an arrest, criminal prosecution remains a public record. Clause 3. The evidence supports a violation of Civil Service Rule 7.2a regarding acts incompatible with and or inimical to the public service, in that by not being honest in her application process and by continuing in a close relationship with a convicted felon, the employee has damaged the reputation of the department. Her relationship with a convicted felon, while at the same time she is a deputy sheriff, is a cause of embarrassment to the department, especially when such a relationship became known to members of a sister law enforcement agency, the El Cajon Police Department. Such conduct is incompatible with the Sheriff Department's executive orders and the mission values and goals. Level of discipline. Although the employee has received acceptable performance evaluations during her period of service in the department, the incident in El Cajon triggered the investigation into her association with a convicted felon. Even assuming the employee did not know that the dismissal obtained by SS does not wipe out completely the criminal record of SS, she did know that the arrest occurred and did know that SS had been convicted of a felony. She should have taken greater responsibility in determining how knowledge of SS criminal history would affect her career. If she had answered the questions accurately, there's no reason to believe that this would automatically disqualify her from being hired. If further investigation revealed the dismissal and good behavior on the part of SS following the dismissal. In law enforcement, honesty is one of the most important qualities peace officers must maintain. The employee, coming from a family where her father is in law enforcement and being a criminal justice major from California State University in Long Beach, should know how important being honest is if one is to succeed in the profession. Therefore, I find the employee's termination from the department should be sustained. Based on the finding and conclusions set forth above, I hereby recommend the following decision: that the order of termination be affirmed, and that the proposed decision shall become effective upon the date of approval by the Civil Service Commission. And I so move.
Do we have a second?
Second.
Is there any discussion?
Point of discussion, May. While I'm in concurrence with Commissioner Montenegro's report, I did want to note specifically related to cause one, two hopes. One, that this would not be taken as an approval or precedent, saying that the particular type of associations or relationship here should be allowed under the policy, and that the department will revisit this policy and make sure that it is clarified and that staff know how to define what is and is not a violation of this policy. I appreciate that it is an incredibly nuanced issue. Taking the example of a sibling relationship, like one of the witnesses provided, I can see that that relationship may be unavoidable, but I believe there's the potential for avoidable associations even within that relationship, where the fact that someone may be a sibling of a felon doesn't mean that they can socialize, go out to the bar every Friday night, or have extensive social contacts necessarily and maintain employment as a law enforcement officer. With that said, I hope that the department will note that it is incredibly difficult for us to evaluate that cause when there's examples provided of things like cohabitation or joint bank accounts. My hope is that we don't establish a precedent where simply opening up a joint bank account can absolve someone of an inappropriate association with a felon or someone else who should not be associated with by a deputy sheriff. And that can be further defined so that we don't run into any similar confusion in the future.
Thank you, Commissioner McGovern. Will the Commissioner Secretary please record votes?
Commissioner Coleman,
Aye.
Commissioner McGovern.
Aye.
Commissioner Montenegro,
Aye.
The report is approved unanimously. That concludes today's meeting. Thank you for attending. The next commission meeting is scheduled for March 4th, 2026. This meeting is adjourned.
Thank you, commissioners.